Hello. Despite the slowdown in real estate sector, NRIs are still keen to buy properties in India. It can be for various purposes besides investment. It can be for family back home or because they want to come down to India at a later date and settle down. But buying property in India can be a complicated affair for NRIs. Hi, I am Dinesh Bhasin from Mint's personal finance team. And in this episode of Why Not Mint Money, we'll look at the common queries that NRIs have pertaining to buying real estate in India. So if you're an NRI or a relative of an NRI, we have answers to the queries that you may have. To make it simpler for you, we will take up the questions first, then give a short answer followed by the explanation. One of the most common questions that NRI have is whether they can buy property in India. The short answer to this question is they can buy property in India whether they are Indian passport holders or they have passport of a foreign country. If you have a passport of a foreign country, then you need to also have an overseas citizen of India card to buy property in India. Typically, a person living abroad would continue to have an Indian passport and permanent residency of another country, or he can be a foreign national with a passport of another country. The term NRI is used loosely to denote a person with Indian roots living abroad. However, according to regulations, the term is applicable only to certain individuals. An Indian passport holder living abroad is an NRI. If someone has a foreign passport and has Indian roots, he will be termed as Overseas Citizen of India or OCI. He will need to register with the Indian government as an OCI and get an OCI card. The Reserve Bank of India recognizes NRI and OCIs on the same footing when it comes to real estate investments. The second common question is, what kind of properties can NRIs buy in India? The short answer is, they can buy a residential and even commercial properties in India. However, they cannot buy farmland, plantation or farmhouses. NRIs and OCCs, that is, Overseas Citizen of India card holder, are permitted to acquire immovable property in India other than agricultural property, farmhouse or plantation. Foreign nationals who are married to NRIs or OCCs can acquire immovable property in India, but it has to be jointly with the spouse and they can only buy one property. But citizens of 11 countries, including Pakistan, Bangladesh, Sri Lanka, Afghanistan, China, Iran, Nepal, Bhutan, Hong Kong, and Democratic Republic of Korea, cannot acquire or transfer immovable property in India, irrespective of their residential status, without taking the permission of the RBI. The next question is whether non-residents can inherit or gift property that is based in India. The short answer is yes, they can inherit as well as gift properties based in India, which also includes agricultural land as well as farmhouses. NRIs and OCCs can inherit and bequeath any immovable property in India. Also, the law permits them to inherit agricultural land and even farmhouses, which otherwise they are not entitled to. There is also no restriction on persons from whom a non-resident or OCC can inherit the property. In fact, NRIs and OCCs can even inherit a property in India from another NRI or OCC. The fourth common question is whether NRIs and OCCs can buy property in India through a company. The short answer is they cannot buy property in India through a company for personal use. Foreign firms that have offices in India have restrictions on property purchase. A company that has established an office in India in accordance with regulation can purchase real estate that is necessary or incidental to their business. But if a foreign company has established a licensing office, it cannot acquire immovable property under any circumstances. In such cases, the company would need to take a property on lease for only up to 5 years. The fifth question that is commonly asked is whether a non-resident can give power of attorney to manage and sell the property. The short answer is that you need a specific power of attorney to be able to do so. The Supreme Court of India has said that properties cannot be transferred on the basis of a general POA. In a general POA, the owner of the property can authorize another person to act on his behalf. So if you want somebody to manage your property, go for a general POA. But if you want to sell the property through another person, then you need to make a specific power of attorney. The next question is, how much money can a non-resident repatriate back to his home country? The short answer is, a non-resident can repatriate up to $1 million in a financial year for most transactions. Like we discussed, typically there is a cap of $1 million a year on repatriation. However, an NRI can repatriate a higher amount on selling the property, provided it meets the following three criteria. First, the property was acquired in accordance with Foreign Exchange Management Act regulations. Second, the money for the purchase had come from a banking channel. And third, in case of a residential property, the repatriation of sale proceeds should be restricted to up to 2 properties. In all other cases, the cap of $1 million will apply. Another common question that NRIs have is whether they can seek relief under the Indian legal system. Yes, NRIs can seek relief under the Indian legal system. They are also covered under RERA, Consumer Court and High Courts. In fact, RERA has boosted the confidence of NRI property buyers. Most of the Indian states have implemented RERA. There are a few states which have not done it yet. Property consultant says that it is best that NRIs stay away from states where RERA is not yet implemented. Also, the residential real estate segment in India is witnessing a slowdown. So if you are an NRI property buyer, avoid buying a residential property for investment purpose. That's all from this episode of Why Not Mint Money. Thank you for tuning in.